Welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All.
Hello and welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All with Eric L. Pines. Eric is a nationally recognized federal employment lawyer, mediator, and attorney business coach. He represents federal employees and acts as in-house counsel for over 50,000 federal employees through his work as a federal employee labor union representative. I'm your host, John Clements. Today's episode is Starting Strong, the first step every employee should take when requesting a workplace accommodation. Eric, welcome to the show.
Hi, it's so great to be here.
Yeah, it's great to have you back. So let's dig into it. So first question, Eric, for employees who are at the beginning of this accommodation process, what's the very first step they should take to protect their rights?
The first step they should take is to reach out to a doctor or medical provider and find out that if they have a medical condition that has some type of diagnosis to it, and whether or not a certain accommodation could assist them. Probably, maybe step one would be doing some, in this generation, an online research. And then step two would be finding the right doctor to support you in your request.
So assembling the right team sounds like the very important key.
Yeah, and it could be a therapist, it could be a psychiatrist, it could be a PA. Does not need to be a licensed doctor, but does need to be a license of some sort.
Okay, got it. Cool. So one thing I interview a lot of lawyers as part of what I do, and the constant refrain I hear is documentation, documentation, documentation. So let's talk about documentation. How do you effectively document an accommodation request to ensure you have that paper trail?
Great question. A lot of it depends on your agency, what forms they use. So step one should just be basically emailing your supervisor or emailing the reasonable accommodation coordinator or the EEO office, depending on your federal agency that you work for. And the second step would be so you want to save those emails. You want to obviously have a paper trail, like you said, because all of that comes together to explain to the judge if there ever is, God forbid, a case later on, then you want to be able to prove things that you sent simultaneously you didn't create later. So that you want those emails, but then step two would probably be to find the correct forms that your agency uses. Like in the Veterans Administration, there's some 400 forms that specifically are used to request accommodation, but every agency has its own set of forms, and use the correct forms if you can. Even though the law doesn't require you to use those forms, you could just request accommodation. That's good enough, but it's always nice to use the exact forms because then your agency knows exactly what's being asked of them.
I see. So you got your email as a business record, of course, you got these forms. I assume also if you're working with a medical professional, there's documentation they're going to give you, you're going to want to keep as well.
Exactly, yes. So you definitely want to make sure when you're talking to your medical provider that you mentioned what this request, or let's say you went to them for medical reasons, you want to mention your medical condition and say, hey, make sure they're putting in their notes, because you may need to use those notes one day to say that you discussed with them what accommodations were necessary for you to do the essential functions of your job.
I see. So, and I guess that's a good question, as does your medical professional need to know that, yes, this is so I can try to get or apply for an accommodation? Will that help them know what information to put in their reports?
Yeah, for sure. They don't have to, but I would see it a huge mistake not to. You want them specific. A lot of times people come to me as a lawyer and they ask me to actually write a letter on behalf of the doctor that I give to the doctor. So the doctor wants to know exactly, they're not lawyers, and they want to be able to see what it is that a person needs. And what the agency that they work for is looking for as far as the legal concerns and the catchphrases that are necessary. So to answer your question, clearly it would be much more beneficial for them to know that you're trying to work with your federal agency to get accommodation.
Yeah, I can see how that would be super important to just have everyone on the same page. You mentioned mistakes, so I want to ask a little bit more about that. What are some mistakes that you see people make when they're, trying to submit for these accommodations that might hurt their case later on?
Not getting a medical provider involved. This is the biggest mistake of all. Let's say you wanted to work from, we're going to use an example. Let's say you want to work from home 5 days a week. If you make a request to work from 5 days to work home 5 days a week, first of all, in the climate today, working home even 1 day a week is going to upset the government. But let's say you make a request to work home 5 days a week, and the government would have potentially allowed you to work at home 2 days a week. So if you make a very forceful claim and use a doctor to say that this client, my patient cannot work unless they're working on 5 days a week, and I will not release them to work. In essence, you're basically saying you can't work at all. Under the law, would make you into a direct threat to yourself if you were to continue to work. So technically, the government should fire you because it's for your own good. So you have to be careful not to request
Mm,
too much, and to make sure that you're clear what you can and cannot do. And if you want to continue working, you have to make it clear either by saying a vague statement like it would be better for them to work from home, or specifically saying they can work at home. I don't recommend this, but I would allow them to do it. It's just not ideal for their condition. So that's probably one of the most important things that I see in my practice.
I see. So we're not. This is not a situation where you want to go with, oh, I'm going to work 5 days a week from home, and then they're going to counter with one, and you're going to meet in the middle at three. Like, that's not probably going to happen in this case.
No, it is. It's just you don't want your doctor to say if he doesn't work from home for 5 days a week, I will not release him or her to work.
Oh, I see.
Because then you're basically saying that you cannot work at all, and they technically, if they release you to work and you get sick, it's their fault.
Mm,
So they have to be
I see.
careful.
Okay, that makes a lot of sense now that you give that additional clarification. So thank you.
Sure.
Let's talk about timelines too, because I'm assuming that if you're going to request an accommodation, there's some kind of timeline or response deadline that you're going to have. And so, can you speak to that a little bit? Like, what does that look like?
So really, this question I can answer quickly. Basically, there is only one timeline that really matters, and that's filing a discrimination case. That which is 45 days from the date that they fail to accommodate you. Even though a failure to accommodate is a continuing thing, sometimes you can argue that. But other than that, most of this is kind of like an art more than a science. You request accommodation, and sometimes they get back to you. It takes them a while. Sometimes they have date time limits on the time you have to respond. So it's kind of a case by case thing. But in general, that 45-day deadline, if you want to file a case, is very important.
So, how would you go about, since it seems like it's kind of a fluid situation, how would you go about ascertaining when that date actually is?
For an EEO case, for a discrimination
Yeah,
case.
yeah, yeah.
A lot of times we like to use let's say the agency rejects your officially, formally on writing, we reject their accommodation. We like to use that date. That being said, I would not be afraid to file a failure to accommodate case anytime, as long as they continue to not accommodate you. But if you want if you want things crystal clear, then you would want to look for that date of the initial denial. And of course, you could always request reconsideration, and that would also re-trigger the date when they respond if they deny again.
I see. And it sounds to me like now we're right back to the first question we asked about, or one of the first questions: documentation, record keeping, and like being able to create that timeline, so that someone like you can help them to do, to file what they need to file.
Exactly. You need to. Well, I'll stick with it's a case by case basis. Like every situation lends itself to individual time limits within it, but it's hard to answer in like unless you know the actual situation other than that 45-day deadline.
I see. Yeah. So, yeah, case by case basis. Obviously, document what's going on. Reach out to someone like you to get that help that you need, and try to get yeah,
Exactly.
yeah. So let's talk a little bit too about rights. So what rights do federal employees have if their accommodation request is ignored, is delayed, it's sat on for an unreasonable amount of time? Do they have any recourse?
Yeah, the recourse is the file the AEO case. We sort of jumped ahead to that a little bit, but I would say that one of the reasons why I specialize in this field and I have such a passion for it is the law is really on the employee side. The way that's written right now, the Americans with Disability Act, which we call the Rehabilitation Act of 1973 in the federal government, really favors the employee. If a person is disabled and they can use it and they can show that this accommodation would allow them to do the essential functions of the job, the agency really has to accommodate you unless it's undue hardship, and that's a very high bar for them to meet.
I see. And again, I'm assuming that as an expert, like, if I were in the situation, I could call you and I could get that guidance for exactly what that means for me.
You sure could. And that's why we
Yeah,
do case reviews that we charge for in this firm, because we're not here to like figure out if we want your case. We're here to educate you and help you do things on your own. Of course, if there is a case, we'll help you with it, that we, along the way. But we want to be able to, it's like be a service to people to let them know that they have their rights and how to assert their rights.
Yeah. So let's say let's say that I've come to you and I've gotten the consultation and I've asserted my rights for this accommodation, and my request is still denied. So now, what are the next steps that I can take?
That's exactly when you would file the EO case. You can file it earlier, but you'll be much more successful. See, what happens is once you request accommodation, there's supposed to be something called the interactive process, where the agency here being EEO office or your supervisor through the EO office, or works with you back and forth to discuss the different options for accommodation. It's called the interactive process. You say what you want, they say what they think would work for you. They don't have to give you the accommodation that you want. They only have to give you an effective accommodation. So they may offer an alternative accommodation, that you have to tell them with your doctor generally if that accommodation is effective for you. And if you don't think so, then boom, you kind of hit a hard stop there, where you might want to file your discrimination case if they come back and if you tell them, I need this alternative accommodation, working home 2 days a week is not going to work for my health reasons, then they'll come back to you and say no. If they do that, that's what trigger your rights, in my mind, when you'd want to file an EEO case.
Got it. So it sounds to me like the agency's EEO office or disability program manager, they're going to be the ones working with you to try to come to a resolution that works for both the government and allows you to do your job.
Generally, that's the case, but sometimes it's the supervisor, depending on the authority that's given to in each agency. I will say that the supervisor, when you request accommodation, the law allows you to ask your supervisor or the EO office, either one.
Yeah. So last question for today then, and it's a bit unscripted, but I am genuinely curious. In the political climate, things are changing rapidly. What advice would you give someone who is trying to go through this process and maybe they don't know what it's going to look like tomorrow?
Well, I'm biased, but I do think it's helpful to come talk to a professional who's dealing with this on a daily basis. And you talked about the political climate, that, like, we have people come to us at least a couple times a week now, where we advise them on whether it makes sense for them to request reasonable accommodation or take some type of buyout, because they're all being ordered to come back to work. And the agencies clearly are taking the stand that everyone should be back at the office, and they, I understand where they're coming from, because it's clearly a humongously important mandate that people come back to the office. But you do have a legal right that nobody in the federal government, whether they work for Doge or the Elon Musk, Donald Trump, President Trump, or anybody working for your agency, it doesn't matter. None of those people have said anything that you don't have your EEO rights. That's the one thing that seems till now to be sacrosanct. And so you have every right to request to work from home under the Rehabilitation Act / ADA. And so I would speak to a professional about whether you fit into neatly into those the laws and the regulations that protect you. Because if so, nobody has taken away those rights as we sit here today. So it'd be great to talk to an attorney to see if you can assert them.
Yeah, and I'm glad you brought that up, because it is easy to maybe not realize or forget that you still do have that avenue to you, and that's something you can pursue. So definitely, call someone like Eric. Eric, it's been a pleasure talking with you today and just learning about this important subject. Thank you so much.
It's been my pleasure as well. I enjoyed talking to you. Take care.
Yeah. And to our listeners, thank you for tuning in to Empowering Workers, Federal Employees' Disability and Employment Rights, and Social Security Disability for All with Eric L. Pines. If you want to connect with Eric, visit pinesfederal.com, and be sure to like, subscribe, and leave a review. And with that, hope you have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.